We have a red card in opposition. Wishing to speak, Meg Garvey. While Ms. Garvey approaches the table, I have a card in opposition not wishing to speak from Peyton Rose Michelle with the Louisiana Trans Advocates. And I do also have a white card would like to speak by Dr. Hall with Louisiana Baptist Office of Public Policy. So if we could go ahead with Ms. Garvey first.
Yes, thank you, Chairwoman. Megan Garvey, on behalf of the Louisiana Association of Criminal Defense Lawyers, in opposition to the bill. First of all, I understand that this is a bill that Senator Koenig is bringing from his heart. I appreciate that. I appreciate the fact that we all want to be here to protect children. I also appreciate the fact that both Senator Koenig and the district attorneys have been trying to continue to work on this because there is some difficulty with the wording, and I appreciate the fact that people have remained open-minded about keeping the law within the Constitution. I was privy to the amendments just this morning, and I do appreciate that 4-year difference. I think that definitely deals with some of the initial unintended consequences. However, I still have problems with the way that the bill is written with the amendment. I do believe that there are still constitutional issues here. I do believe that there are vagueness issues in violation of the Fifth Amendment, overbreadth issues in violation of the First. The way that I see the law and the case law that I read in preparation for this morning suggests to me that the kind of behavior that we are seeking to prevent is already made illegal by attempt indecent behavior. And I read some case law for that effect. So when I'm looking at the amendment, which I was really excited that there was going to be an amendment, was hoping it was going to fix everything. But just the very definition of inappropriate relationship, what does that mean? I think if it's a sexual relationship, I think that would really go after the kind of behavior that we're talking about, because I think inappropriate can mean different things to different people. I also think that one of the issues that I think the state would have with this bill is that I think not only because of the way that the law is written, I think there's constitutional issues, but I think that the law in and of itself invites an unconstitutional trial. And what I mean by that is I think that there will be a temptation to bring in certain kinds of evidence that may be later found on appeal to really just have had a prejudicial effect. I think that I just think it's going beyond criminalizing the behavior that we actually want to criminalize. I also think that the way this is written is so broad that I think it's going to have a chilling effect on people who genuinely want to volunteer to take care of children, to be teachers, to be coaches, to have anything to do with children, because I think this opens itself up to be possibly a little bit of a witch hunt, because it's just using words like inappropriate, things like that. Now, if somebody were to make a proposition to a child, right, and there were a prosecution for that, I do think that a judge would probably, and I think it would be upheld, would allow the state to bring in what we call prior evidence or 404B evidence to show that these things existed to back up their allegations of intent.
Thank you, Ms. Garvey. And while we typically are not aligned, I do appreciate your efforts as well. I know you were up late
Yes.
and early as well,
Yes.
working on that. So
Yes.
I do want to acknowledge
Yes, ma'am.
that.
Thank you.
Rep. Walters.
Thank you, Chair. Thank you, Meg, for your commentary. Can you explain to me in like simple terms? I'm not an attorney, so like just simple
Yes.
terms.
Yes,
some of what you were saying, because I was following you, and so can you kind of just go over you know how they had a show, Are You Smarter Than a Fifth Grader? Right now I'm not.
Okay.
So can you go over in regular terms what your opposition is?
Well, very specifically, I think my opposition is to some of the specific words. I think the phrase inappropriate relationship I don't like, because I think it's broad, and I don't think it actually targets what we're seeking to target here. I think that it should be sexual, because that's the law, that's the crime, that's the kind of action that we're seeking to prevent. So I think that could tighten it up. And then as to these other words, emotional manipulation, promises. Like, I don't know necessarily what that means, right? I think if you're prosecuting somebody for trying to solicit a child to do something sexual or inappropriate, then I think you could use those other facts to maybe flesh out your allegations and to show evidence of motivation. But I think those are big, broad words that have different meaning to different people and different meaning in different contexts. So I still feel like it's a little bit overbroad and could possibly draw in people who have no ill intent. So, I mean, and I understand that the response to that is probably going to be like, well, it says intent to commit a sexual act, but it doesn't even require an attempt. It doesn't even require asking or making those comments to somebody to be convicted of this.
Okay. Thank you.
Thank you, Rep. Walters. Senator Connick, would you have any objection to inserting the word intimate? I understand that the 404 article Ms. Garvey just referenced does use that language, and would there be any objection if we reconsider the amendment and add intimate to that?
Madam Chair, I'm looking at over my DAs or the experts. They have no objections to
Mr.
that.
Daniels?
And last thing we want to do is create a bill that's going to hurt
Absolutely,
innocent
and
people.
that's why I'm
But the last thing the main thing we need to do is go after these people who are really
Absolutely.
preying on our children.
absolutely.
And causing
To the
harm.
extent if we believe it makes it stronger, I would have no problems offering that amendment. If we think it weakens it, that's a different story. Mr. Daniels, can you guide
Zach
me?
Daniels, Executive Director, Louisiana District Attorneys Association again. No, I think intimate relationship is in Code of Evidence Article 404. Therefore, the case law has already interpreted what that means. It is consistently, in my research, referenced the sexual relationship. I think part of a hesitance or preference to intimate versus sexual would be the sexual relationship, I think, is more captured in the intent provision, and the intimacy is part of that antecedent behavior. So I think we would balance the concerns here while also utilizing existing language from the statute or Code of Evidence article that was referenced by Ms. Garvey.
Thank you. So, Mr. Gonzalez, if you could help walk me through, what do we have to do? Reconsider the First Amendment set? Okay. So I would offer a motion to reconsider Amendment Set 3276. And Mr. Gonzalez, if you could help me.
Yes. Are there any
Is there any
objections?
objection to reconsideration of the amendment set?
Okay.
No objection. Let that amendment set be withdrawn.
So, yes, so now a motion to withdraw the set.
So I offer a motion to withdraw Amendment Set 3276. Any objection? Hearing none, let Amendment Set 3276 be withdrawn.
And so now this new set that originated in committee, it's my understanding that the contents of this 3276, that is all still there and being offered. The only change is the word inappropriate is being changed to intimate.
Are we changing inappropriate, or are we doing
Or-
inappropriate intimate?
Or
My suggestion would be to replace if the word inappropriate was a part of the objection and based on it not being defined. The intimate relationship, I think, would capture
Okay.
the same theme of
Okay.
the original word.
So Mr. Gonzalez is correct. So on C1,
point.
okay, well, that's fine. On C1, we would change inappropriate to intimate. So I would go ahead and offer that amendment. Do we have any objections? Hearing none, let that amendment be adopted. Ms. Garvey, did you have something?
I have an intimate relationship with my mother. I mean, it's
That's
just
fine.
like such
I
a-
understand,
a
but
hard
I
word.
think when we look at the Article 404 and the court's interpretation of that, I do think that the bill is stronger by replacing inappropriate with intimate, and for that reason, that amendment that's why I offered the amendment, and it has been
Yes, ma'am,
adopted.
I appreciate that.
No, I appreciate you. Thank you. And it does appear that the board is clear